about the terrorism charges against Nnamdi Kanu is that they are also a witch hunting charge. Why I said so is because when you look at the ingredients of the offense of terrorism, you must be able to establish a direct connection between the alleged offense and the alleged offender. Currently, there is not even a single piece of material evidence connecting whatsoever that is happening in the southeastern Nigeria with Mazi Nnamdi Kanu as we speak. And even before now, that they are alleging that he made some communications that may have indirectly or directly influenced some activities in the southeast, are all unproved. They are all tainted with a lot of speculations. Now, let me give you an example of how the law works. If you are alleging that Mr. A killed Mr. B, you have to present how Mr. A killed Mr. B. You have to bring up the real evidence used by Mr. A to kill Mr. B. Either it's a gun, either it's a knife, whatsoever it is, you have to bring it. You cannot just speak and say it has happened and then we should all agree that it has happened. No. I am being factual in law now. This is our practice and procedure. This is also part of the evidence law of Nigeria. If you are saying that Mr. B had indeed died, it's either you bring the corpse of Mr. B or you bring a certification to show that Mr. B had indeed died. Now, let's go to the offense of terrorism, which Nnamdi Kanu is starting for. Before Mazi Nnamdi Kanu started agitating for the freedom and the equal rights and treatment of the Igbos, in 1966, Ojukwu commenced that struggle, which 1967 to 1970, we saw a dark period in Nigeria, which nobody is happy about or is happy to remember of. However, just some years down the line, the Igbos were being killed, the Igbos were being marginalized, the Igbos were being oppressed in the country, not just the Igbos alone, even the Yorubas and the Hausas in some other parts of the states in Nigeria were also being killed, were also being marginalized. However, the one that was looking more outspoken, more clear, was the one that has to do with what? The Igbos. Now, the Igbos came out and started agitating. As a reasonable head of state or as a reasonable head of the executive arm of government, what were you supposed to do if you had common sense as a president then? You would have just called these people to a roundtable meeting and dialogue with them and understand the pain in their hearts. The truth is this: a woman who is saying, I want to divorce my husband, I want to divorce my husband, please sue my husband, I want you to file a petition for dissolution of marriage, might not really want a dissolving marriage. It is just a gimmick to bring her husband to dialogue with her, so as to get maybe better treatment or better welfare. I strongly believe a lot of persons who are saying today that they want to break off from Nigeria, a lot of them, if given the real opportunity to really say their mind, they don't really want to separate from the country, but they want a country that is not just for one particular side or a tribe. They want a country that is inclusive. They want a constitution that properly defines the rights and obligations of collective Nigeria and not just a particular sector. They want a particular constitution that would not be in any way discriminating against them. The Igbos have time again said it, that they are being discriminated against in the country. And as the president, the only thing you could do was to try to muzzle them. Of course, that doesn't work. If you call for a referendum, you have to first of all amend Section 1, Subsection 2 of the 1999 Constitution. Because you cannot call for a referendum without amending the provisions of that section, which says that Nigeria shall be one indivisible state. So by the time you now amend it, you give the people the free will to vote. Don't be surprised. Just like Brexit, we had a close call. Some person said they wanted to leave. Some people said they wanted to go. However, the people that wanted to actually stay, the Britons that wanted to stay with the EU, was close to 49%. Very close. Now, if we are to have this kind of democratic system in Nigeria, where people are called to come and speak up their mind in the eastern part of the country, don't be surprised that the elites and even those that they would also influence will vote to stay. That will solve the problem of what? Of separation. Then you now address other key issues. What happened to Governor Sim Fubara is an example of what we call absolute power vested in the what? Federal government. The governor of a state was never removed. That's one they said for 6 months that he was not the governor or he was not the one operating River State. Is because he did not have the muscle to go and take back his office. There is no provision in law. In fact, it is even going to be an aberration if you people, journalists, should make a declaration that he was removed for 6 months. He was never removed. The proclamation of Mr. President is tantamount to an offense. That declaration that was also legitimized by the National Assembly was legitimizing an offense. Are you aware that it is a treasonable offense to declare the seats of the president, vice president, governor, or deputy governor vacant without following the due process of law, either by virtue of section 143 or section 188 as it relates to removal of either the president or the governor? The president, if not because of the fact that he has immunity under section 308 of the 1999 Constitution, he would ordinarily have been subjected to treason charges, because what he did in River State is a treasonable offense. And that is the reason why I said that if Governor Sim Fubara had his own military might in River State, the sole administrator wouldn't even see the light of the day there. It is going to be a war. The governor will sit down in his power. If you want to declare state of emergency in accordance with section 305, you have the right to actually declare a state of emergency. You have the right to bring in military support to support me, not to say they are taking over my seats. They are coming to support me because I am overwhelmed. That is what the Constitution presumes. The Constitution presumes that the governor has become overwhelmed. The current state security personnel he has are not sufficient for him to contain insurgency or emergency, either by natural disaster or by human intervention. Then the president steps into what? To reinforce the security he has, not to come and sit on his throne. A democratically elected leader cannot be charged for any offense in Nigeria. Governor Sim Fubara, if he had had a face-off with the sole administrator will be charged to court in a same country, not this one we are operating nonsense democracy, in a same country that has real democracy. That sole administrator, if he had had a face-off with the governor, will be charged for treason, for even trying to lay a finger on the governor. But the governor was gagged. The governor was muzzled under the table, and even came back and was applauding Mr. President. Automatically, he has even legitimized the aberration that was done on him by even thanking Mr. Who are you thanking? That is why I don't blame women for saying that it's like women have more balls in Nigeria today, because look at Senator Natasha. She never apologized for anything. She never thanked anybody. After the period of the suspension, which of course I feel that our own case is quite different, because under the Senate rules, they can discipline her. Okay?
Not that long.
Yes. So, but the one that is even, in fact, if the justices of the Supreme Court of Nigeria, the late justices, those ones that we know that they were the one that helped us today to have certain things that we are enjoying, if not because of the ruggedity of our past Supreme Court judges, that were very rugged. They took no nonsense. When President Olusegun Obasanjo declared the office of the vice president vacant, in the case of Attorney General of Federation versus Atiku, 2007, the Supreme Court held, without any form of fear, that you cannot whether directly or indirectly, declare the office of the vice president vacant. You don't have that power. That is the same thing that just happened this year in this country, and everybody kept quiet. Even the judiciary, who I am a member of as a part of the bar, I felt so bad that this matter could not be expeditiously heard and determined, at least to save the sanity of our what? Of our democracy and constitution. This matter was just left hanging and have finally been turned to academic and swept under the carpet. Now tell me how posterity wants to judge each and every one of us, especially within my own profession. Honestly speaking, I feel so bad that things that should be taken very seriously, because when you keep allowing President Bola Ahmed Tinubu to go away with a lot of things, you are giving him what we call absolute power. The judicial arm of government, who by virtue of Section 6 ought to ensure that the Constitution is being upheld to the highest level, is now keeping quiet because of procedural defect and what have you, which of course we all know that a former Chief Justice of Nigeria has stated that we have left the time of technicalities and now we are now in the time of substantive justice. Even the great Oputa has stated in the case of Adekoke Motors against Adesoya and others that we are final, not because we are infallible, rather we are infallible because we are final. The justices of the Supreme Court of Nigeria are human beings capable of erring. It will be short-sighted arrogance not to accept this obvious truth. That is the words of Justice Oputa of blessed memory. Honestly speaking, I am using this as a conscious and professional call that I believe we, the judicial arm of government, have a whole lot of role to play in ensuring that our democracy in Nigeria is not one that is run by one man. Honestly speaking, the rule of law is preferably than the rule of man, because as we are in Nigeria, it is as if we are experiencing the rule of man and not the rule of law.